Here.
Dr. Hawkins?
Here.
Dr. Lewis?
Present.
Mr. Warmoth?
Here.
Dr. Yip?
Yes.
Ms. Wright? Here. We have four.
I'm now going to turn over to Judge Anderson.
Hey, good morning, everyone. I'm Judge Mary Margaret Anderson from the Office of Administrative Hearings, and I'll preside over the oral arguments this morning. So we're now on the record before the Medical Board of California. It concerns the matter of the petition for modification of probation of Joshua Peter Litwin, MD, and the board's case number is 800-2015-014014. The OAH number is 2015-090506. Today's date is July 28, 2016. It's a little after 9 in the morning. We're at the Embassy Suites Hotel in South San Francisco. This is the time and place set for the oral argument on this matter. So, we'll start with opening argument by respondent.
Thank you so much. My name is Mitchell Green. I'm the attorney for Dr. Litwin. And Dr. Litwin, who is a board-certified ophthalmologist, is sitting by my side. In 2014, Dr. Litwin agreed to accept a probationary license. He had had a prior history of chemical dependency in Washington State where he was licensed. So quite appropriately, the probationary license included terms in this regard. Those terms are not at all at issue in this case. In fact, there was a history of, I think, 7 years of sobriety prior to the granting of a probationary license. There's even, I think you'll find a footnote in the proposed decision confirming not an issue in this case, nor is there any issue of patient care. What is at issue is a very significant proctoring requirement. 150 proctored surgeries and procedures. And I suspect you may all recognize that on its face as a very burdensome requirement. And this was included notwithstanding the fact that there had not been any issue of patient care in Dr. Litwin's prior history. After accepting the probationary license, Dr. Litwin attempted to comply, but encountered unforeseen difficulties in doing so. Indeed, some of the difficulties were unforeseeable insofar as there was no hint of certain requirements and restrictions on the face of the disciplinary order to which he had agreed. Some of the restrictions, in particular those relating to the proctoring requirement for cosmetic surgery, I am sorry to say, those difficulties are the results of requirements that were imposed by the people supervising the probation, and they are unfounded. They don't have a legal justification. They're bad policy, and they don't make any sense. They don't comport with common sense. You will note from my statement to the board, those are the issues that I have focused on because I think they are the most problematic for Dr. Litwin in his ability to comply with the terms of the disciplinary order. The restrictions that were imposed serve principally to prevent Dr. Litwin from complying and demonstrating his competency. And that's going to be one of the themes you hear in my presentation. Dr. Litwin wants to comply. He has tried to comply. He has proceeded in good faith to comply. And the petition is the result of his inability to do so and his attempt to come into compliance and reshape the order into one he can comply with, demonstrate his competency, assure the board that the public is being protected, and complete the requirements in a timely manner consistent with the probation. Indeed, the cooperation between Dr. Litwin and the probation department has generally been excellent, and in fact, I think it's quite distinctive. The petition for modification was filed at the suggestion and urging of his probation officer. you will see the statement included in the record, the proposed decision as follows. My personal suggestion to you is to petition for modification of your probation to eliminate the proctoring requirement altogether. You will have almost a year of practice to show that you are back up to speed in your field of medicine. You can argue the obstacles which you've experienced regarding the proctoring requirement. So, following the advice of his probation officer in all matters, because it has always been Dr. Whitman's purpose and intent to comply and cooperate, he filed his petition. The relief he sought was denied, and that's what brings us here today. The notice of non-adoption does not really offer any clues about what particular matter the board is concerned about. So I'm going to assume that the board shares some of the same concerns I share and that Dr. Litwin shares regarding the enforcement of disciplinary orders and the modification process. And to that extent, as is often the case, the issues in this case go beyond just narrowly the facts applicable here and go to those broader issues about the modification process. The concern we have, and the one I hope you share, is that as much as the board must insist on strict enforcement of stipulated orders, it also needs to assure that as a practical matter, a physician acting in good faith is able to comply with the order, and it's not an impossibility, it's not a labor of Hercules that is beyond doing. Anything other than that really does undermine the integrity of the board's enforcement efforts, and it crosses a line between discipline for the purpose of protecting the public and just straight out punishment. Some of the key facts about this case that I'd like you to keep in mind, if you would, as you consider it, are these. This is clearly a case of a good faith, honest effort to comply. He may file the petition after running it by his probation officer and on her suggestion. It is a timely matter, particularly so, and I think Dr. Litwin's foresight should be noticed and credited. We have a probation order that ends in March 2017. It says that if you fail to comply with any term of this order, your license is subject to revocation. Dr. Litwin is not sitting around waiting for March of 2017 to pipe up, I couldn't do it. He's being proactive. He's seeking the assistance of the probation officer and now the assistance of the board in molding an order with which he can comply. The relief he seeks is appropriately tailored. There's no overreaching here. He didn't come in and seek to abolish or eliminate the probation order and seek an early termination of it, which is certainly permitted by the statute and is typically the case chosen and the path taken. Instead, he's trying to tailor something that keeps the order in place and allows compliance. The limitations and burdens that he's facing in compliance, in particular regard to the cosmetic surgery restrictions, are not of his own making. They were imposed on him without any kind of earlier knowledge or notice on the face of the agreement he entered. And I question and hope the board will question both the legal basis and the wisdom of the requirement that prohibits the out-of-state compliance. And I'll address that a little bit more in a moment. There are actually 3 different sets of proctoring requirements. Our statement to the board focused on the cosmetic surgery requirement because it is most problematic. Like each of the other 2, it requires 25 surgeries as a assisting surgeon and 25 surgeries as a primary surgeon. As the board points out in its papers, yes, indeed, Dr. Litwin did agree to do those 50 cosmetic procedures, and he was prepared to do them, and he was prepared to have a proctor. He not, at least at first, have any problem complying with that proctoring requirement. He was ready and willing and able to return to Washington State to fulfill the proctoring with a Dr. Sobel. Dr. Sobel was a mentor. Dr. Sobel is a board-certified cosmetic surgeon. Dr. Sobel is the medical director of a nationally accredited fellowship program, and he is locally prominent. And just like each of you, he sits on a state licensing board. It's not the medical board, but he's an osteopath, and he sits on the state board for osteopaths. Yet, it was the case that the people supervising the probation refused to approve Dr. Sobel as a proctor because he was not a California physician. And that is in the record. I'll note for you at page 28, not at page 78. It was a typo in my statement. The question I think that I'd like you to pay attention to, if you would, is where does that requirement come from? And what's the basis of it, and what good does it serve? It certainly does not appear in the statutory authorization that the board has to impose discipline by probation. Business and Professions Code 2228 certainly does not disqualify competent, eligible, credentialed physicians in 49 states from in any way participating in the rehabilitation and remedial education of the physician. And nor should it, as a matter of policy. It is an unwise policy. By that same token and by that same reasoning that was applied, I think on a very ad hoc basis, and I think without any policy or legal support, by that same token, a nationally prominent program out of the Harvard Medical School, out of the Mayo Clinic, out of Johns Hopkins, out of NYU, would be insufficient and unacceptable to allow for satisfaction of the proctoring requirement. And that simply does not make any good sense. Here Dr. Litwin has an opportunity to go to a particularly well-suited program, one that does not raise any issue of certification, qualification, objectivity, reliability, one that meets the heightened standards of board certification. And he is being told that he can't do that. He is being denied the opportunity to comply with the order that was imposed on him. He is being denied the opportunity to demonstrate his competency, all out of what I hope you all recognize as a very provincial restriction. I'm not sure that that's the message this board wants to send to the medical community of the state of California. That we don't accept Harvard Medical School. We don't accept the Mayo Clinic. We don't accept NYU. There really are two fixes to this problem. First is the one we requested in our briefing in front of the medical board, in front of the hearing, which was terminating the cosmetic surgery requirement. Why it's in there is really not at all clear. As the record showed, Dr. Litwin never practiced cosmetic surgery. He went to a cosmetic surgery fellowship, basically to learn cosmetic injection technique, injection being different than surgery. But this is not a person who has ever done a facelift, a nose job, a tummy tuck. That's not his practice. He has no skills, he has no certification, he has no privileges, never had, never will do that. His surgery, cosmetic surgery, is only to the extent that it overlaps with eye surgery. Never his practice, never an intent to do it, never a present intent to return to it. He couldn't. He'd have to go be completely retrained. Sort of like making an internist go do proctored cardiac stent procedures just because his license would theoretically permit him to do that. Well, that's true of every license for every physician in this state and every other state. They're unencumbered licenses. You can do whatever it is you are otherwise qualified to do. And the principal gatekeeper gatekeeper, and the principal protection for the public in that regard does not come from the board. No disrespect. It comes from the medical staffs of hospitals that are the gatekeepers. They determine what privileges you can do. They impose their own proctoring requirements. And they're the ones who keep internists from doing brain surgery. So license.
Mr. Green, just to let you know, you have 3 minutes.
Okay. If the board feels that the cosmetic surgery requirement needs to say, then let Dr. Litwin comply. Let him do it. Let him satisfy it. Let him go to Dr. Sobel in Washington. It's in the interest of public safety to allow him to demonstrate it. It's not in the interest of public safety to prevent it. The same issue is true of cosmetic injections. And you'll see from Dr. Sobel's letter, this man is an expert in cosmetic injections. He was teaching other doctors how to do it. So we ask that you allow him to satisfy that cosmetic requirement by going to Washington or get rid of it completely. He's made a good faith effort.
Thank you. For the Office of the Attorney General?
My name is Greg Chambers. I'm a Deputy Attorney General who has represented the medical board in this matter. Today we heard 4 times that the respondent or the applicant has acted in good faith. And then we heard statements that the medical board is denying the applicant the opportunity to work in his chosen profession. And yet, as you will see in the documentation that was presented by the medical board, the applicant didn't work in good faith to complete the terms and conditions to which he had agreed. There are 6, 7 very well-known hospitals in the Bay Area, and in examination at the hearing, applicant stated he did not knock on any of those doors. He could have been proctored at any one of those places possibly. He would have needed to receive privileges there. It seems to have been a circular argument. Can he get privileges without being proctored? Can he get proctored without privileges? We don't know because he didn't knock on the doors. The medical board is not denying him the opportunity. He denied himself that opportunity. Now, should this individual be given time on top of his current probation to achieve and complete the terms and conditions? That may be possible. But he didn't take the first steps. He completed the PACE program. He completed the biofluid testing. He's completed 50% of what was required of him. But condition 2 of that probation term that laid out 25 proctored exams in 3 areas, and then 25 proctored examination of procedures in which he's the actual principal committing those committing the procedures. He didn't do that. And it wasn't because of the medical board. It was because of his own inaction. And so when there's an argument that the medical board needs to look outside the state in the interest of public interest, well, that's the reason why it doesn't look outside the state. It's because of public interest. The medical board is concerned about the public interest of the state of California. There are great doctors at Mayo Clinic. There are great doctors at NYU. There are great doctors at Harvard. There's equally great doctors at UCSF. There's equally great doctors at Stanford. There's equally great doctors at Mills Hospital. There's equally great doctors at Alta Bates. Their doors were knocked on. So now we're to believe that a doctor at Harvard's going to receive a knock at the door? I don't think so. Let's take the first steps. Let's deal with the people that are in California, those that are licensed here, those that we can talk to. And that's the position of the medical board at this point in time. Thank you.
Thank you. Mr. Green, back to you for 5 minutes, and then Mr. Chambers, and then we'll see if the board has any questions.
Sure. 3 quick matters. What the record shows here is that Dr. Litwin is a community-based physician in Berkeley. Is a largely underserved, economically challenged population. He has really no hospital practice and no real need for a hospital practice other than the cardiac and those types of surgeries that he would do. He went to the bylaws of a community hospital nearest it was Alta Bates, And it says, nobody who is on probation can get medical staff privileges. Okay? That's in the record. Did he go knock on every door in every hospital in the Bay Area? No, he has no affiliation, no connection, no community relation with any of those hospitals. That issue goes principally to eye surgery, not to the cosmetic surgery, because what Dr. Litwin did was he took the comments in the disciplinary proposed decision to heart. He's continued his efforts to find a proctor. He's actually, as of this time, submitted a name. It's been under consideration for 2 months by the medical board for their approval to do the eye surgery part. So the focus on this presentation, as I said at the very beginning, is on the cosmetic surgery part. And yeah, there are good doctors in California, and there are good doctors all over the country, but how does Dr. Litwin get to the doctor? Does he need privileges at UCSF in order to operate at UCSF to satisfy the cosmetic surgery procedures? Yes, he does. Does he have to go get privileges at UCSF if he can't get privileges at Alta Bates? That is the notion that we can't satisfy proctoring requirements out of state with highly qualified people is just an extraordinarily provincial notion in today's age. You know, there's no obvious, apparent, or even foreseeable benefit, added protection for the public or plus to restricting the satisfaction of this requirement in state when it does pose requirements, and when a physician is able to get something set up that satisfies all the legitimate concerns that the medical board can possibly have about quality, competency, objectivity, and public protection, to add on without any prior notice to him, without any statutory basis, without any regulation, without any guidance whatsoever, and after the fact, that he can't satisfy that where he thought he could when he signed that declaration is grossly unfair, and it prevents this board from doing exactly what it is supposed to do. Give him a chance to comply so he can demonstrate his competency, and you can be assured that he's protecting the public and that you are protecting the public.
Thank you. Mr. Chambers?
Quite frankly, I think anything I would state would be just a restatement of my previous petition, so I will see my time. Thank you.
Thank you. All right, let's see if any of the members of the board have any questions. Can I start on my far right? Yes.
I do. I'd like to know, in the record, did you submit the staff bylaws of the various institutions that are in the Bay Area to support your statement that anybody who is on probation cannot receive any privileges to be proctored?
I did not, no. I submitted the bylaws of Alta Bates, which had that term.
Okay. Because it's a little concerning for me is that we have a lot of institutions in the Bay Area, and there's a statement in the, I guess the ALJ's, Mr. Chambers' comments that none of these hospitals did Dr. Litwin contact personally to ascertain whether each bylaw had that type of restriction.
That is accurate. He did not go knock on every door at every hospital or even any other hospital other than Alta Bates. Alta Bates was the hospital that was most closely affiliated with the community in which he practiced. He had no patients in other areas. That's where he practiced. But I want to emphasize for you at this point, that issue goes only to the eye surgery because he has available. There's no requirement that it be the same proctor for everything. In fact, there have to be different proctors because there are different board certifications required. So totally regardless of whether he, 2 points, totally regardless of whether he knocked on every door in the Bay Area, the cosmetic surgery issue stands separate and independent. He's prepared to satisfy Dr. Sobel in Washington State. And the issue of whether there's any justification or wisdom in restricting it to out-of-state, the in-state people stands. The second point is, as I've mentioned, he has pursued this now, and he's kept at it, and he has submitted the name of a proctor, and that proctor has been under consideration for 2 months by the board now. The plan as presented to the board was not to get credentials at a hospital, because he can't, but to do it through this doctor's affiliation with a surgery center. Now, whether the board's going to approve that, or whether I said the board, let me be clear, the probation people are going to approve that, or whether they're going to generate another objection along the lines of the cosmetic surgery objection, that a surgery center is not as good or equal to or satisfactory in the way that a hospital is. I don't know, but my fear here is in that regard is that the state of mind is one of generating obstacles to compliance rather than working with the physician in a practical way that assures credibility but allows compliance.
Okay, so let me understand this. You said there are surgery centers that have been contacted, or a surgery center that has been contacted for potential proctoring abilities? Or,
no,
that's what
there's
I'm hearing
been
you
a
say.
proctor who's been identified who had surgery center, his name has been submitted for approval to the board as is required by the order. This proctor had surgery center privileges, and it was his creative idea that Dr. Litwin would not need to have hospital privileges, that he would attempt to get him into the surgery center with the kind of privileges necessary to satisfy the proctoring. That proposal is now under consideration by the board, where it has been for the last 2 months. So I'm trying, at least for the purposes of this proceeding, to draw a line between the cosmetic surgery, the cosmetic injection, and the eye proctoring requirements. The ALJ made the comment that, what you take away from the ALJ's report is the eye issue is a more complicated one. We're able to satisfy the cosmetic surgery, but for this apparently arbitrary restriction, we are working again on the eye surgery issue.
Okay, thank you.
Any more questions from that side of the room? No? Yes, Judge Feinstein?
Thank you. I have a question, and perhaps the passage of time may provide an answer. But I know in your papers you stated in a number of places, and you also restated here this morning, that Dr. Litwin has no intention of practicing cosmetic surgery. Yet when I read, I believe it's the PACE report, and I believe it's page 9 of 14, it talks about what he did with his fellowship with Dr. Sobel, and what he basically did was all cosmetic surgery. And, given that, as you said, when you have a license to practice medicine in California, you have a license to practice medicine. I don't understand why someone would spend a year doing a cosmetic surgery fellowship and then say, oh no, I have no intention of practicing cosmetic surgery.
Let me give you a couple of answers to that. I think that the testimony is Dr. Litwin went there principally to become expert in the injection process, which is the most dramatic overlap between eye surgery, one of several overlaps between eye surgery and cosmetic surgery. Number two, I suggested in the papers, and even provided some suggested language, he has no objection to any language in any sort of order that prohibits him or subjects him to a penalty or some kind of review or anything if he goes into cosmetic surgery. He's willing to agree to any language the board wants. I've given you some suggested language, but this is not his intent. And number three, Dr. Litwin was in a diversion program in Washington State, something akin to the diversion program we used to have here. And to some extent, his employment opportunities were limited, and he chose to take an opportunity to advance his education and improve his skills and his medical knowledge while he was trying to figure out how he was going to survive under those circumstances. But the decision to do the comprehensive review of cosmetic surgery as well as eye surgery was PACE's, and I suspect that they did it for exactly the same reason that you're questioning things now. And you'll notice there was some testimony. The review in cosmetic surgery was distinctly different than the review of his eye surgery skills. His eye surgery skills, according to PACE, were exceptional. But his review for cosmetic surgery was not, and it wasn't any surprise to Dr. Litwin, and as he explained in the hearing, it's because he doesn't do that, never intended to do that. So, yes, he did take that course. Yeah, there was a limited purpose of it, but...
It was a year.
Yeah. But, the short answer is, if you have any concern in that regard, we're amenable to any language that you feel necessary to put there. This is not an end around or subterfuge, please. It is not. Whatever language is necessary, we'd agree to it, and we even suggested some.
May I ask a follow-up question? Of course. Please. It seems from just being a member of society that reads newspapers and local publications and watches television and what have you, that there are many settings under which people can obtain cosmetic injections or other things short of cosmetic surgery, be it they by licensed dermatologists or, even these med spa clinics, which one learns about on this board. They're venues that are short of a hospital and certainly short of a surgery center because that level of care isn't required. And my question is why Dr. Litwin, if what he needs to do is have these procedures observed, wouldn't pursue a different venue, a dermatologist or something like that?
Well, because let me give you a couple of answers. First of all, the requirement is a board-certified cosmetic surgeon. That's in the order, okay? These are, you are right on the money here. The cosmetic injections are procedures that are typically performed under the supervision of a doctor by a nurse at a med spa when done for cosmetic purposes. And why the board originally felt it necessary to have him do 50 cosmetic injections as a term of the probation is a little bit bewildering. It's not a high-risk, complicated procedure, but he can't satisfy the requirement with a dermatologist because the disciplinary order doesn't allow it. If the board wants to change the disciplinary order and provide for that, great, we're happy to do that. And he would anticipate doing some cosmetic injection as a revenue supplement for his practice, but he draws the line between injections and cosmetic surgery. He has no interest in doing cosmetic surgery. And as I said, we'll accept any restriction imposed in that regard.
Does the Attorney General's office have any comment on my questions?
We have no further comment.
Any other questions from this side of the room? Okay, seeing none. And is anything else for the record today? Hearing none, that concludes the oral argument in this matter, and we're off the record.
Thank you.
We're now going to go into closed session.
And please, they'll need to get the court reporter form, and then they'll be able to proceed. So just take a minute. Mr. Green,
Yes.
don't forget
Oh,
your
I'm
court
sorry.
reporter form.
I apologize.
That's all right. Court
Oh, we're
reporter,
going to the
yeah,
court reporter.
he's filling it out for you, and just take a moment. Of the First Amended Statement of Issues against Dr. Paul Lopez in case number 800-2015-016095. The OEH case number is 2015-10, I'm sorry, I'm going to say it wrong again. 2015-110219. Today's date is July 28th, 2016. It's 10:30 in the morning. We're at the Embassy Suites Hotel in South San Francisco. This is the time and place set for the oral argument on the non-adoption of the proposed decision. My name is Mary Margaret Anderson. I'm an administrative law judge assigned to preside this morning. Let's start with the appearances for the record. Let's begin with the Attorney General's office.
Yes, good morning. My name is Michaela Mingardi. I'm a Deputy Attorney General representing the Medical Board of California in this matter.
Good morning, Ronald Marks. I'm appearing on behalf of Paul Lopez, who's also present.
Thank you. All right, Mr. Marks, so it's over to you with the first 15-minute session.
Thank you. Good morning, members of the panel. I'm here today to argue in favor of the Administrative Law Judge's proposed decision. First of all, under Business and Professions Code, Section 2335, when considering a proposed decision, the board or panel shall give great weight to the findings of fact of the Administrative Law Judge. The ALJ's findings in this matter were amply supported by the evidence, and therefore the panel should give great weight to those findings. In my written argument, I've summarized the evidence supporting the findings and the decision, and there's certainly not enough time to go over those arguments today. But what I would like to do is highlight some of the issues regarding PACE. From the inception of this case, the board staff and complainant has focused unfairly on phase one of the PACE evaluation. Acting on the application of Dr. Lopez, a stipulation was prepared and submitted which almost exclusively mischaracterized the findings of PACE by focusing almost entirely on phase one aspects of the PACE evaluation. This stipulation would have been a public record, as you know, and therefore it had to be rejected, and a request was made on behalf of Dr. Lopez for an administrative hearing. According to the PACE guidelines, and I'll just briefly encapsulate them, the 2-day phase one assessment is not sufficient to make judgments about competence. Both phase one and phase two of the assessment are necessary for complete, informed judgment regarding competence and safety for practice. Therefore, Dr. Cedarquist violated guidelines by PACE by making a recommendation in phase one that Dr. Lopez could return to practice under supervision. I also think that in a way, Ms. McGarty's focus on the results of the computer test in phase one, in which Dr. Lopez apparently did not do well on 2 of the cases, even though it's not indicated how many cases there were, is a bit unfair by not also including the follow-up with Dr. Schulman after that computer examination, in which Dr. Schulman indicated that Dr. Lopez got 7 out of 8 diagnoses correct. His overall score was satisfactory on 4 cases and superior on 4 cases. And the PACE report's conclusion regarding Dr. Lopez's interaction with Dr. Schulman was that Dr. Lopez demonstrated good to excellent medical knowledge and clinical judgment during their discussion. At the end of PACE 2, which the panel should primarily focus on, the following conclusions, among many other favorable conclusions, was made by the PACE evaluators. Dr. Lopez's clinical judgment was superior for all cases except one, case 4, and it was satisfactory. He demonstrated very good medical judgment and considered an appropriate differential diagnosis throughout. His diagnostic, therapeutic, and disposition decisions were also quite appropriate. Dr. Lopez's counseling skills were very good, including an explanation of findings, pathophysiology, diagnostic and therapeutic options, and ensuring the patient's understanding. And one more that I would like to bring up. Dr. Lopez's average overall clinical competence score was 6.6, which places him near superior. The only recommendation would be to brush up on some physical examination skills. He otherwise performed quite well. Based upon all the evaluations and the consensus of the PACE physicians, it was recommended that Dr. Lopez could return to practice with only 50 extra CME hours per year for two years. That was the recommendation. And that's the recommendation that was adopted by the administrative law judge based upon the evidence. The 50 extra hours would be of no problem for Dr. Lopez. As he testified at the hearing, he completed 415 hours total in 2013, 2014, and 2015. If there's time left, I would ask that the board allow him to explain and elaborate on that. In addition to the extra CME that he has taken, he's employed in a non-medical capacity in the medical clinic, which has allowed him to interact with physicians on a daily basis, which keeps him up to date on medicine and new developments in medicine. He testified about that at the administrative hearing. I bring it up because we're not offering new evidence. That's in the transcript, page 59 to 60, and he can elaborate on this if time allows and the board permits. I would also submit the Business and Professions Code, section 2221A, mentioned by Ms. McGarty, is not applicable here. Business and Professions Code 2221A states that the board may deny a physician's and surgeon's certificate to an applicant guilty of unprofessional conduct or any cause that would subject the licensee to revocation or suspension of his or her license, or the board in its sole discretion may issue a probationary physician's and surgeon's certificate to an applicant on various terms and conditions. However, an order that's based on sole discretion at this point in the case would be improper. There's been a statement of issues, there's been an administrative hearing, there's been findings. To exercise sole discretion now would be a denial of due process and a denial of a meaningful hearing. The evidence that was presented on PACE are the terms and conditions that the board should consider. And for many years, the board has placed utmost reliance on the PACE evaluations. So this is nothing that the board should weigh without the weight that it's been given throughout the years, even including PACE in disciplinary orders. that must be complied with. It is undisputed that Dr. Lopez practiced successfully with a clean record for 20 years, his entire medical career. He voluntarily agreed to go through PACE and be evaluated by PACE. And PACE concluded that he could safely return to the practice of medicine with extra CME. Dr. Lopez does not present a risk to patients. He should be granted a return of his medical license. It should be returned under conditions that allow him flexibility, that will allow him the flexibility to practice in a setting that would give him the most gratification at this stage of his career. Now, if the panel's concern is the way the order was phrased by the administrative law judge, it could be modified. It could be modified as long as it's consistent with the findings and conclusions at the hearing and is determined by the administrative law judge. Perhaps the order could be rephrased to 2 years probation on standard terms and conditions, with the exception of the requirement of 50 hours per year of the 2 years of probation, extra CME. I don't think that would be an unreasonable modification of the LJ's proposal. If there's any time left, Mr. Law Judge, would it be appropriate for Dr. Lopez to address the panel with respect to elaborating on some of the evidence that was presented at the administrative hearing?
Yes, would he like to address the panel?
Yes, I don't know how many time is left. I didn't keep track.
About 5 minutes.
Right.
Okay, all right, then I need to swear him in for the rules. You can remain seated, sir. Please raise your right hand and be sworn. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you. What would you like to tell the panel today?
Thank you for hearing my explanation here. I just wanted to go over
The microphone.
I just want to address the issue that since year 2014 and even before, I've been taking CME courses credits to an average of about 100 per year. In some of the years, I did a little bit more. Like in the year 2015, I obtained a total of 219 credits, hours. And the courses were in very renowned institutions such as UCLA,
Your Honor.
USC.
If I could just, my computer's gonna shut down and for some reason.
Okay, we're just off the record for a minute. Don't worry. That's all right. You ready?
Yes.
Please continue. And could you bring the mic just a little bit closer?
Oh, sure it can.
That's it, huh? Okay, all right.
Closer.
All right.
So I have taken those courses in like USC, UCLA, UC San Diego, and one of the courses was a review in internal medicine in Columbia University in New York. That is a world-renowned university. And for this year, 2016, I had already taken 176 hours credits in mostly in internal medicine, such as hypertension, diabetes, obesity, and those courses were done in UCLA, CEDARS, CNA, UCLA for a family refresher course, and I also taken the internal medicine course in Columbia University again. So I'm trying to go beyond what it was said, the base, not just 50, but like in year 2015 was 200 hours, and this year I'm already 136 hours. Okay. Whatever question you guys may have, the likely
All right.
ones.
Thank you. We may get to that in a few minutes.
Okay.
Thank you. All right. You have just a couple more minutes, but I'll go over to the AG.
I'd also like to just elaborate on behalf of Dr. Lopez that he does work in a non-medical capacity at a clinic, working with the doctors. He's been there for many years, and that's another way, besides the CME he's been taking to keep up with the new developments in medicine and with the interaction with physicians. It's a place of employment.
Thank you, Mr. Marks. Ms. McGarty.
Thank you, Your Honor. It certainly does appear, based on the record, that the respondent is a suitable candidate for licensure, and I don't think anyone's disagreeing with that. It seems that the central issue is what conditions, if any, should be placed on the granting of his license after being out of practice for more than 15 years. That's a long time. And I think that when you look at the record, you look at all of the evidence presented, and as counsel noted, we have to look at both phases of PACE. One phase is not to be completely disregarded. Certainly, in looking at the findings of phase 1, the results were mixed. They were varied. Respondent performed well in certain categories, but he was lacking in other categories that gives certainly the board concern about how he should restart his practice once his license is granted. And just to point the board's attention to several of those findings to keep in mind. In Exhibit 5, which is the PACE report starting with phase 1, they reported pages 2 through 5 that respondent did display low average medical knowledge overall, and he did score unsatisfactory on 2 cases. In the computer-delivered tests, which aren't to be ignored, he took unfavorable actions in 2 cases. One was categorized as risky, and one is harmful. And that was at Exhibit 5, page 5. In phase 2, he did perform better, and certainly you want to see improvement. That improvement is significant and is duly noted. However, they did find that he overall lacked some primary care knowledge and was not quite up to date in certain areas that were of concern. And PACE came back and said, based on these concerns, we recommend an additional 50 hours of CME per year. That recommendation certainly is considered and is certainly valuable, but PACE doesn't decide what conditions are placed on an applicant's license. It's the medical board's purview and the medical board's jurisdiction. And we do consider, and certainly Business Code and Professions Section 2221A is applicable. It is the board's sole discretion, considering all of the evidence based in the record of what those conditions should be. And we believe strongly that the correct conditions, as conceded by respondents' counsel, would be a 2 to 3 year probationary term with the 50 hours additional each year of CME, and an additional condition of either no solo practice, and if the board feels that that's onerous, certainly a practice monitor seems reasonable in this situation where the respondent has not practiced for more than 15 years. It sounds like with his practice in his medical group, a practice monitor should be readily available and not an onerous provision, and it gives the board that extra protection on public safety, knowing that he's being guided during his probation and becoming up to date in the field after such a long absence. And certainly the standard terms and conditions, as was omitted from the original proposed decision, would be necessary, as I think defense counsel just conceded, an appropriate term in probation. That's all I have. Thank you.
Thank you. All right. Mr. Marks, back to you for 5 minutes.
Thank you, Your Honor. I agree that PACE doesn't decide what kind of conditions should be placed on a probationary license, but I think that it's not totally up to the board to propose probationary decisions that are not consistent with the evidence. And the only evidence in this case was the PACE evaluation, which, as you know, Dr. Lopez went through for a whole week with various reputable physicians for the sole purpose of determining whether he could return to practice without the conditions that counsel was proposing. PACE did not recommend that he be monitored. PACE did not recommend that he be supervised. PACE did not recommend that he be limited to practicing in a non-solo practice. It gets back to my point that the board has discretion, certainly, but it must be, that discretion must be exercised consistent with the evidence. And there was no other evidence other than the PACE report as to what would be, in their opinion, consistent with the public protection. The fact that if Dr. Lopez were placed on probation, 2 years probation, consistent with the PACE recommendation, and complied with the conditions, the standard conditions of probation, which means that he will have a probation monitor. He will have to make reports to the board on a periodic basis. He will have to cooperate with board investigations. What are board investigations? It can be anything from looking at records, investigating complaints, and whatever the board thinks is necessary to make sure a physician is complying with probation. Those are conditions which are not unreasonable, but they're not onerous, and they're reasonable in this particular case based upon the evidence. Thank you.
Thank you. Ms. McGarty. I would simply just like to add that I think the requirement of either no solo practice prohibition or in particular a practice monitor is certainly supported by the evidence in this case, the PACE report, and would be consistent with the board's mandate to protect public safety. Thank you.
Thank you. All right, we'll go and see if the board members have any questions, starting from my left. Any over here? No? To my right. Yes, doctor.
Thank you very much. Dr. Lopez, could you tell us how your experiences in the clinic that you're at now are contributing to your ongoing medical education and keeping up to date?
I do what is called patient care referrals coordination. One of the doctors will see a patient and say, this patient needs a CT scan of the chest.
Is a what, sorry?
CT CAT scan of the chest. So I look at the records, I explain to the patient, say, Mrs. Smith, the doctor is suggesting that you have a CAT scan of the chest, you have been a smoker for 30 years, the doctor is thinking that you could have a problem in the legs and so forth. The patient understands if there is any question, the patient will ask me. Then I go to the referral coordinator and I say, the doctor wants a CAT scan, please submit a referral, a request from the proper plan, HMO, whatever. And I'm interacting with the patients, with the doctors, with the referral. I look at the diagnosis, I see why they are ordering. That brings me up to date, what are the guidelines. A lot of times the specific health plans, the NHMO, whatever, will ask for more information. Why Dr. So-and-so is asking for this particular test? What is the indication for that? What is the reason for that? So I need to go to the doctor and say, hey doctor, why are you ordering this? So I interact with the doctor. I'm up to date. I see the guidelines submitted by the health plans. Sometimes we get rejections of those tests that are requested. We get a letter saying HMO plan is denying the request for a CAT scan of the lumbar spine or an MRI of the lumbar spine. So I need to go to the doctor and say, the plan is rejecting that. Can you provide more clinical indications? Can you provide more information? And a lot of time I contact the plans and say, this is the reason why the doctor is ordering. This is the reason why this particular diagnostic testing disorder and so forth. So that's the interaction we have.
Just briefly, are you in the room with the doctor when the patient is being talked to, examined, or anything?
Only when the doctor asks me and says, can you explain to the patient what are we doing?
Thank you.
Dr. Lewis?
Yes, along the similar lines as you described your clinical practice setting, which I would like to hear in a little more detail about the environment. In addition, the type of physical contact, physical exam contact you have with patients, if any.
I'm not allowed to touch the patient. I'm not allowed to do a physical examination. I can talk with the patient. I get the information from the patients. I get a full history, if you will. I have the records in front of me. However, I cannot perform a physical tap. I'm not allowed to. But after the doctor finishes, and a lot of times, I would say in a fair number of cases, I am with the doctor there when he's doing a physical or whatever. He asks me, it's not every single patient that comes of a routine thing, but if the doctor called me and said, hey, can you explain to the patient that he, she will need further diagnostic testing, we need a referral for surgery, we need a referral for whatever. In those cases, I am with the doctor, with the patient, and the patient is asking, why is this, why is that? So I take the part of educating, the educational part of the process. Now, again, I cannot go and perform a physical. I'm not allowed to do that.
So the type of practice setting is called by what name? The type of practice?
It's a primary care practice. Here we have 2 internists and 1 family practice there. It's primary care, basically. And whenever there is something else, we refer out. Whenever we need diagnostic testing, we send it out and so forth.
Okay, thank you.
Thank you.
Any other questions from the panel? Okay. Is there any other argument or anything else for the record today?
No, no.
No, Your Honor.
That concludes the hearing, then we're off the record. Counsel, please wait for the court reporter form. Hector has it, and he'll get it to you as soon as he can.
Thank you.
Thank you.
After that, we're going to go into closed session.
I know it's